4. State bears on the list is Janan Dempsey.
I'm probably mispronouncing it.
Janan. Yeah.
Ms. Dempsey, I think you've seen these counts earlier. They were refiled in a long form complaint, but I'll go over them in a little bit more detail with you.
What's a long form complaint?
Do you have a copy of the long form complaint?
I don't know what that is. I've got too much paperwork here.
All right, it should look. It's not a citation that's written on one of the printed forms, traffic ticket citation form. It's a long form complaint.
I should have a copy of it. Can I ask you, what are the grounds for reviving the dismissed case?
That would be up to the prosecution.
So the prosecutor's not here today.
Prosecutor's not here today.
So I can go for motion to dismiss for failure to prosecute.
Well, actually, you may file whatever motions you like, ma'am. Let me make sure you've got a copy of this long form before we proceed. This is what it should look like. You can take this copy if you don't have one.
Okay. I have the original citation from probably over a year ago.
No, that's not
And-
a citation. That charge was dismissed, and so they are refiling it in a long form complaint. I believe they're the same charges.
That's what I'm confused on. What's the difference between a long form and the original citation? It's got the same counts.
Under the criminal rules, an officer can issue a citation in the field, which is the form. It looks like a traffic ticket form, but it has the same information in there. Or the officer can do the investigation, report the investigation to the prosecutor, who can do a long form complaint, or in this case, the officer can swear out a long form complaint. There are multiple ways that a criminal charge can be filed.
I guess I'm just, like I said, I'm confused because it got dismissed.
It was dismissed without prejudice, meaning it
Right.
can be refiled.
It can be refiled. Okay, do we have a probable cause statement with asserted facts?
You're looking at it right there.
Okay, that's not the nature and cause in this, though.
Well, you can file whatever motions you like, ma'am, but I need to proceed with the arraignment this morning.
Okay,
Okay?
sure.
So according to the long form complaint then, in count 1, it's alleged violation of 132916A1. And that's the use of electronic communication to intimidate, threaten, or harass. You'll see that there are multiple subsections of that statute. Yours is only A1. Any violation of any of those subsections by the statute is a Class 1 misdemeanor. The statute also defines what is electronic communication, and I'll give you a copy of that statute here in a moment. As a Class 1 misdemeanor, it could have a fine of up to $2,500, 6 months in jail, or both. This particular charge is a presumptive fine, including surcharges, because it has a domestic violence designation, of $803.30. I'll write that on the form.
Can you, for the record, can you, just to, the category of DV is to share domicile, be married, or have child in common? Yes?
That's true, plus it can be a close family relationship, such as mother-daughter.
Okay. I have not been married to this man, never lived with him, and actually it's going to be burden on the court to prove that we share a child in common because a paternity hasn't been established yet.
Well, okay,
And that's a whole nother
that's-
separate case I'm going through right now with DES.
Okay,
So.
that's something you should address with the prosecutor, because the prosecutor
Okay.
can remove that designation.
Okay.
Okay?
Mm-hmm.
In count number 2, it's also 132916A1, 2 different counts. It appears from the long form that you're looking at there that this was 2 different incidents that occurred on the same day of January 23rd of 2016. So there's really 2 counts.
4 total, yes?
Yes.
Okay.
Count 3 is in violation allegedly of 132921A1, which is harassment. That's a little bit different statute. It's not involving the electronic communication, but it's a similar sort of charge. Again, it includes its own definition of what is harassment. A1. As a Class 1 misdemeanor, it also has the same range, up to $2,500, 6 months in jail or both. That statute, again, does not have any jail time associated with it, and the presumptive fine with surcharges that are put in because of the domestic violence designation would be $803.30. And that is count 3. Count 4 is in violation of 131202A1, threatening or intimidating. That is also a Class 1 misdemeanor. Same range, same potential fine. Do you have questions about what those statutes
No.
are, what the counts are? All right.
No.
I have a separate section here that I'll hand you. It's statutes on domestic violence. It includes the 3601 definition of what is domestic violence. And then the second half wouldn't be applicable because that's just talking about the order of protection. I'm assuming we're entering a not guilty plea on your behalf, is that correct?
Actually, in order to make an informed plea, I need to have a probable cause statement, a sworn affidavit of fact from the DA or an alleged victim in this case, which there was none. And in fact, that was another thing I wanted to clear up with you. The warrant that was issued on the 4th, and I would have been here to appear, but I was doing an address change. So when they actually arrested me at work. So I just want to get that cleared up. But on your warrant, whoever issued that, it still has the same counts from the original citation on there, and no summons and no probable cause statement attached to the warrant. And that has to be there in order for it to be valid. Courts are constitutionally forbidden to issue warrants without such a statement signed under penalty of perjury by requesting the warrant. Well,
when the warrant was issued, it was issued with the misdemeanor complaint. The complaint does have a probable cause statement.
It has reasonable cause. The probable cause is the who, what, why, and where to establish personal jurisdiction matter. Not the nature and the offenses.
Well, Ms. Dempsey, I've already determined that that was sufficient probable cause. That's why I issued the warrant. You can renew that with some sort of a motion if you wish.
Okay, I need to subpoena the summons, the original summons, please.
I'm sorry?
I'm gonna have to subpoena the original summons.
The original summons?
Yeah, the summons that are supposed to be attached to the warrant when it got served. And the probable cause statement. A sworn affidavit. From what I understand, it just can't be the offenses listed on the warrant. If there's no facts asserted in a probable cause statement, supporting those elements of the charge makes for no valid probable cause and no valid warrant.
Okay, I've explained to you that the probable cause statement contained with the misdemeanor long form complaint I found to be sufficient. That's why I issued the warrant. So,
But it's not attached to the warrant. It was supposed to be attached to the warrant as when I got served. And this warrant wasn't actually given to me after I got processed and got out of jail.
Well, that's something you can renew.
That's something I will bring up in court, yes.
Yes.
So I'll just file a written objection and address the defective warrant and lack of probable cause.
Fine. That's good. Meanwhile, we're going to not guilty plea when we